Good morning, all. The Subcommittee on Capital Markets will come to order. Without objection, the Chair is authorized to declare a recess of the committee at any time, and this hearing is entitled, Examining the Department of Labor Fiduciary Rule, Implications for Retirement Savings and Access. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the Chair for inclusion in the record. Before I give my opening statement, I just want to mention that we've opened an overflow room for additional seating in 2220. So anyone who would like to go upstairs to Rayburn 2220, we have seating there for you. I now recognize myself for 5 minutes to give my opening statement. Thank you all for joining us today for this very important hearing, which addresses a crucial issue affecting the accessibility of affordable and dependable retirement investment advice for millions of low and middle income Americans. America is facing a retirement savings crisis. A 2023 Federal Reserve report highlighted that nearly 28% of working adults have zero retirement savings. Washington needs to empower individuals to save for retirement, not make it more difficult. Sadly, the Department of Labor's latest proposed fiduciary rule will do just that. Disguised as an attempt to eliminate so-called junk fees, the Biden administration's proposal would push retail investors out of transaction-based investment accounts into fee-based investment accounts. Millions of Americans prefer the low costs of transaction-based accounts because they want a one-time, affordable, high-quality financial advice. Should this proposal be finalized, it would leave millions of Americans who are just starting their retirement savings journey without access to sound financial advice, resulting in higher costs, lower choices, and reduced service. This proposal is the Department of Labor's fourth attempt since 2010 at disrupting the client-advisor relationship. The Department of Labor was forced to withdraw their first proposal after receiving a flood of opposition from retirement savers and broker-dealers. Then they lost in court twice when they tried to revive this harmful proposal. I've been pushing back against this misguided effort ever since I came to Congress in 2013, and I am in utter disbelief that we are still having this fight. This latest proposal is yet another bite at the same rotten apple. It should be withdrawn immediately. Financial professionals are sounding the alarm about increased compliance burdens, limitations in product offerings, and restricted access for consumers. Should this proposal be enacted, many would have no other option but to increase or impose minimum asset thresholds for clients, closing the door on financial advice for many. As we saw when the 2016 rule went into effect, this proposal will shut millions of low and middle income Americans out of the financial advice market, and we would be left with 2 classes of investors: those who can afford investment advice and those who cannot. Moreover, the Department of Labor's proposal is yet again a solution in search of a problem. Existing federal and state regulations, like the SEC's Regulation Best Interests, Reg BI, and the National Association of Insurance Commissioners' Best Interest Standard for annuity sales, have been established to safeguard consumers seeking financial advice. These regulations, coupled with ERISA's existing 5-part test, fully protect consumers seeking retirement products and financial advice. I'd like to enter into the record a letter sent to the Department of Labor regarding the 2016 fiduciary rule. This letter was signed by 93 House Democrats, including the subcommittee's ranking member and many other members sitting on this subcommittee today. In this letter, the signers state that, and I quote, "In order to have a successfully implemented rule, it is vital that the proposal doesn't limit consumer choice and access to advice, have a disproportionate impact on lower or middle income communities, or raise the costs of saving for retirement." The letter also expressed the signer's recommendation that the proposed rule address annuities and not disadvantaged lifetime income options. Without objection, I offer the letter into the record. I wholly agree with these demands made by my colleagues and would hope that since this new DOL proposal does not meet their demands, they will join me in opposing the proposal. I look forward to hearing from our expert witnesses who will explain further the damage this proposal will have on retirement security in America. I yield back, and the chair now recognizes the ranking member of the Subcommittee on Capital Markets, the gentleman from California, Mr. Sherman, for 5 minutes for an opening statement. Happy New Year to you, sir, and Happy New Year to the entire committee. You have 5 minutes.
Happy New Year. The chair is correct. We do have a problem where people have not saved and are not able to save for their retirement. And keep in mind, that's before this new rule becomes effective. It's not this new proposal that is the reason people have not saved for their retirement. Wages are too damn low, and organized labor is an important part of making sure that people get paid enough to be able to save for their retirement. It also illustrates how important it is that we not privatize or cut in any way Social Security, since we're probably going to continue to have a circumstance where people find it difficult to save for their retirement. The regulation before us has those who hate it, those who love it, put me in between. The fact is that we need to improve this regulation, but I think ultimately we need a regulation in this space. The most important improvement would be to add to the regulation itself material that's found in the preamble to the regulation, so that it is clear that the regulation is not supposed to deal with choose me discussions, is not supposed to where somebody's saying, please have me as your advisor, does not have to deal with proxy advice or generalized advice or discussions of how you're allowed perhaps to take money out of your IRA and give it to a charity. Many charities are happy to provide you with that advice, and they usually have an idea as to which charity should benefit from your largesse. So a lot of what's in the preamble needs to be as legally binding as the rest of the rule. We see an incredible balkanization of regulation designed to protect investors. We have 3 different committees of Congress involved: the Ag Committee, the Labor and Education Committee, and ourselves, all involved. And when it comes to dealing with retirement funds, we get 3 different agencies of government involved. We get the SEC, we get the Department of Labor, which is why we're here today, and we also get the Department of Treasury, which, as I understand it, has not bothered to adopt any regulations, in spite of the fact that it solely has jurisdiction over protecting your IRA. So we have best interest regulations in most of this space. What are the exceptions? Well, there's an exception when you have a guaranteed insurance product. Now, that is subject to state regulation, which requires best interests. If you're in one of the 40 states that has followed the rules of the National Commission of Insurance Regulators, that is to say, the National Association of Insurance Commissioners. The second area you have is where there's going to be an investment in something that is not classified as a security. That includes some insurance products. It also includes commodities when you're investing in from your IRA, because the Department of Treasury has chosen not to impose any national regulations there. And then finally, because money in your IRA doesn't benefit from these protections, what becomes very important is the decision to move your money from your employer's ERISA plan to your IRA. And it is that decision that is an important part of the proposed regulations. I think the states have done a good job of regulating insurance products, but I'm concerned when there are 10 states that don't follow the National Association of Insurance Commissioners models, because they may not only fail to provide support for their people in their own state, but you may have an ERISA plan headquartered in Delaware. You may have an insurance agent or a broker or company in Delaware, and if Delaware for some reason isn't part of this, the retirement funds of somebody in my state may be implicated. So we ought to require the best interest of the investor to be protected, and we've got some loopholes to fill, and I yield back.
The ranking member yields back. And today, now, we'd like to welcome the testimony of Mr. Jason Berkowitz. He is the Chief Legal and Regulatory Affairs Officer at the Insured Retirement Institute, IRI. Mr. Marc Cadin. Mr. Cadin is a CEO of Finseca. Mr. Bradford Campbell. Mr. Campbell is a partner at Faegre Drinker. Ms. Susan Neely. Ms. Neely is the president and CEO of the American Council of Life Insurance. And Ms. Camilla Elliott. Ms. Elliott is the CEO of Collective Wealth Partners. We thank each of you for taking the time to be here. Each of you will be recognized for 5 minutes to give an oral presentation of your testimony, and without objection, each of your written statements will be made part of the record. Mr. Berkowitz, we'll start with you. You are now recognized for 5 minutes to give your oral remarks.
Good morning, Chairman Wagner, Ranking Member Sherman, Chairman McHenry, and members of the Capital Markets Subcommittee. My name is Jason Berkowitz, Chief Legal and Regulatory Affairs Officer for the Insured Retirement Institute. IRI is the only trade association that represents the entire supply chain of the insured retirement industry, including insurers, distributors, asset managers, solution providers, and others. Before I begin, I want to thank the Chairwoman and many others of other members of the subcommittee for your longstanding commitment and dedication to ensuring that individual investors are protected by standards that serve their best interest without depriving them of access to valuable financial products and services. And thank you for the opportunity to appear before you today. I am eager to share our views about the DOL's so-called retirement security proposal. Retirement savers face many risks as they strive for financial security in their golden years, not the least of which is the risk of running out of money. Protected lifetime income products help them manage this risk, and professional guidance helps them acquire and use these products appropriately. Congress recognized this when it enacted the Secure Act and Secure 2.0, bipartisan laws designed to enhance our nation's private sector retirement system by expanding access to these valuable products and services. Contrast this with the DOL's proposal, which is functionally equivalent to its 2016 rule, and like that rule, will harm millions of low and middle income retirement savers, especially those in communities most impacted by the wealth gap, by depriving them of access to the products and services they need to achieve a secure and dignified retirement. Retirement savers should be able to select their preferred source of professional guidance to help them prepare for retirement, and to choose retirement savings strategies and products that best fit their individual needs. The DOL's proposal would deprive many retirement savers of this opportunity to make their own choices. To be clear, we believe all financial professionals should be required to act in their client's best interest when providing such guidance, as they are already required to do under the SEC's Regulation Best Interest and substantially similar rules that have been adopted by now 41 states and counting. IRI has supported these important measures which provide regulators with the tools they need to protect retirement savers and appropriately address the conduct of bad actors. With these rules being actively enforced, The DOL's proposal, as the Chairwoman noted, is a solution in search of a problem. Most financial professionals are good, hardworking people who want to do right for their clients. If bad actors are exploiting regulatory gaps to harm retirement savers, regulators should seek to address those gaps through precise and targeted rulemaking. While the department has hypothesized and speculated that retirement savers could be hurt, it has produced no evidence that any of these theoretical regulatory gaps are actually being exploited to harm retirement savers. Without such evidence, a targeted approach is impossible, so the DOL has instead proposed to completely upend the existing regulatory framework. But why? As stated in the proposal, the DOL believes it, as opposed to other regulators, is uniquely positioned to effectively protect retirement savers. But ERISA only allows the DOL to regulate the conduct of fiduciaries, so it must shoehorn more financial professionals into fiduciary status, regardless of whether that standard is necessary or appropriate in any given search situation. The proposal would cause nearly any interaction with a retirement saver to trigger ERISA fiduciary status, which is often described as the highest standard under the law. ERISA fiduciaries must act solely in the interest of the plan for the exclusive purpose of providing benefits to participants and beneficiaries. This goes far beyond a best interest standard, and as a federal appeals court recognized when it rejected the DOL's 2016 rule, should apply only when there is a special relationship of trust and confidence. The DOL has tried to circumvent that court decision by asserting that such a relationship exists whenever a financial professional makes a recommendation to a retirement saver. We disagree. A special relationship of trust and confidence cannot spring into existence spontaneously, but rather must be intentionally cultivated over time. Pretending otherwise and allowing this proposal to take effect would only serve to deepen the nation's retirement crisis and further exacerbate retirement insecurity among America's workers and retirees. Instead, the DOL should recognize the limitations on its jurisdiction and let other regulators like the SEC and the state insurance departments do their jobs as Congress intended. This proposal is not fixable. It is not needed, and that is why IRI urges its withdrawal. Thank you again for the opportunity today. I look forward to answering any questions you may have.
Thank you, Mr. Berkowitz. Mr. Cadin, you are now recognized for 5 minutes to give your oral remarks.
Chair Wagner, Ranking Member Sherman, Chairman McHenry, I want to thank you very much for holding this important hearing. My name is Marc. I'm the CEO of Finseca. Finseca was created to reunify the financial security profession in order to advance the cause that inspired our name, financial security for all. We are comprised of more than 9,000 professionals who serve consumers by providing access to investment products and holistic financial advice. Collectively, we refer to our members in the broader profession as financial security professionals, or FSP. At its core, this hearing is intended to define what is in the best interests of Americans in terms of how they receive financial information and guidance, and what has been proven both by the experience of the profession Finseca represents and by independent experts like Ernst & Young and other thought leaders, is that a holistic financial plan is an essential element to achieving financial security. EY's research proves that consumers that have permanent life insurance, investments, and annuities, those consumers that have all three, they get better outcomes. The question then is, how do we equip more Americans with a holistic financial plan? And the answer is simple. They need guidance from a financial security professional. But make no mistake, if the Department of Labor is successful in pushing through yet another ill-advised, offensively framed, substantively bad, fiduciary-only proposal, the result will be the regulatory burden will be so great that literally thousands of FSPs will find it impossible to do their job. And the result of that will be a massive loss of financial guidance to millions of Americans, particularly those who need the advice the most. Yes, millions of Americans will be left less financially secure. If adopted, this rule will take the country in exactly the wrong direction, as we already face a $7 trillion gap in retirement savings. We face a $12 trillion protection gap, according to estimates from LIMRA. And with the looming insolvency of Social Security on the horizon, we are literally on the brink of a financial crisis. But fortunately, there has been an overwhelming coalition of members of Congress in a bipartisan fashion to address the financial insecurity of ordinary Americans. And with the support of both the current and former presidents of the United States, you've enacted important pieces of legislation like the Secure Act and Secure 2.0. And frankly, I want to thank every single member of this subcommittee, because not a single one of you voted against these important pieces of legislation. Thank you for your leadership. But unfortunately, the Department of Labor has determined that it knows better than you. In fact, the Department of Labor has consistently demonstrated an unwillingness even to follow other regulators that know the profession, regulate the profession more often than they, and each of whom have decidedly rejected a fiduciary-only approach. The DOL has shown no deference to the Fifth Circuit's unambiguous ruling that they don't have the authority to issue this rule. So the department has shown no deference. They don't have the authority to issue the rule. It's actively thwarting the bipartisan will of Congress. And without question, if the DOL is allowed to move forward, this rule will hurt real Americans. And I'd like to close with a story about one of those Americans. In the early days of a pandemic, a grandmother named Mary Jo placed a frantic call to her financial security professional, a Finseca member named Armin from Colorado. Mary Jo had just started a new job, unpaid, but the best kind. She was a full-time nanny to her grandkids. And as you all recall, at the early days of the pandemic, the stock market was tanking, and unfortunately, so were Mary Jo's retirement savings. She was panicked. She thought she'd have to go back to work. But thankfully for Mary Jo, she and Armin had put together a holistic financial plan which included an annuity, a consistent and stable source of income. Mary Jo immediately had the reassurance that she could keep the favorite job she'd ever had, being a full-time nanny to her grandkids, being a granny nanny. Finseca strongly encourages you, our congressional leaders, to adopt a no-funds amendment prohibiting the department from moving forward with this proposal. Mary Jo and millions of other Americans like her depend on it. Thank you very much, and I look forward to your questions.
Thank you for your testimony, Mr. Cadin. Now, Mr. Campbell, you are now recognized for 5 minutes for your oral remarks.
Well, Chair Wagner and Ranking Member Sherman and the rest of the committee, I want to thank you for the opportunity to testify today. And I want to start out by stressing that the views I'm expressing here are my own. I'm not representing a client. I'm not representing my firm. I'm not representing the views of my colleagues. What I am representing are my personal views based on my experience as a practicing ERISA attorney who routinely advises clients on matters of fiduciary obligation, on the prohibited transaction rules, and also because from 2006 to 2009, I was the Assistant Secretary of Labor for Employee Benefits, head of the Employee Benefits Security Administration, the agency at DOL that is now proposing these rules. And based on that experience, I'd like to share some observations with this committee about the proposals. Ordinarily, I don't think the Financial Services Committee would pay much attention to what the Labor Department was doing in a regulation because you wouldn't have a reason to ask the question of what are the impacts on the capital markets and on the financial services provided to individual retail investors and retirement savers. But this isn't an ordinary rule. I want to commend you for taking the unusual step of reviewing a Labor Department rule in this committee because the Labor Department has taken the unusual step of attempting to insert itself into the retail marketplace for financial services to individual retirement folks, disrupting insurance, securities, and banking financial markets that this committee oversees. Individual retirement accounts and individual retirement annuities collectively hold more than $13 trillion, with a T, trillion dollars in assets. And under current law, Congress established that there is no separate standard of care, there is no separate remedy for services provided to those IRA owners. Instead, Congress inserted the regulation of advice to IRA owners into the existing financial services system. The IRA owner chooses who they go to seek financial services from, and that's regulated by the state insurance commissioner or by the SEC or by the other appropriate entity. Congress did the opposite of this with employer-provided retirement plans under ERISA, because those are not individual retail products. Those are institutional trusts in which someone else is making decisions for workers. So in that case, Congress said, yes, we are creating a special fiduciary standard for these institutional organizations where workers don't make their own decisions. And yes, we're putting the Labor Department in charge of that. That is not what they did with IRAs. But that is what the department's proposal is seeking to do. It is seeking to export the rules that were designed for this special employer-provided situation into the $13 trillion retail marketplace for individual retirement savers that Congress never intended to have apply in that space. And they do this through, I'm just going to call it a clever trick that I like to call the DOL two-step. And the first step of that is they dramatically expand the definition of what is considered fiduciary advice for purposes of the prohibited transaction rules in the tax code. Through a quirk of the law, DOL regulates those prohibited transaction rules both for ERISA plans and for tax purposes. The effect of that is that ordinary, perfectly legal and appropriate transactions in which, for example, there is a commission paid to an insurance producer or a broker-dealer, now become illegal prohibited compensation by virtue of calling that a fiduciary relationship. That brings up step two of the two-step. In step two, the department says, all right, well, we will create an exemption that allows you to still be able to get paid for providing that advice, but only if you comply with an extensive series of new conditions, one of which is the imposition of a standard of care that is almost identical to the fiduciary standard of care applicable to employer-provided benefit plans. In other words, DOL through the back door tries to impose a standard on IRAs Congress denied them the ability to impose through the front door. Now, all of the conclusory statements I just made about congressional intent and what DOL has the authority to do and what it doesn't are not my own opinion. This is what the Fifth Circuit Court of Appeals said when it overturned and, vacated the 2016 rule the department used, which had a very similar two-step built into it. And the effect of all this will be for the Labor Department, if these proposals were to be enacted, the Labor Department would have an entirely new federal regime that of regulations with significant details of reporting, disclosure, et cetera, a whole new extensive regime that would apply at the same time as state insurance law, at the same time as regulation best interest or the regulation of RIAs as fiduciaries. So you would have competing regulatory systems simultaneously applicable to the same advice to the same people in an IRA. And that is clearly not going to result in lower costs. That is clearly not going to result in greater access. I know I'm over, and I'll just close with one last thought, which is I've heard a number of people say, well, it'll be different this time. The Labor Department has changed this proposal compared to 2016. People aren't going to lose access to advice. I did myself lose access to advice.
Gentleman's time's expired.
In 2016. And if it can happen to me, it can happen to anyone else.
Thank you, Mr. Campbell. Ms. Neely, you are now recognized for 5 minutes for your oral remarks.
Well, thank you, Chairwoman Wagner, Ranking Member Sherman, and members of the subcommittee for holding this hearing on the important topic of the DOL's fiduciary rule and its impact on access to retirement security. I'm Susan Neely. I'm President and CEO of the American Council of Life Insurers. And life insurers, I think, as you know, are deeply committed to the mission of retirement security. In fact, we offer the only retirement product that provides guaranteed income for life. I will also add my thanks to that of my colleagues to you for your leadership on advancing Secure 1.0 and 2.0, a major policy legislation, two pieces of policy legislation passed in just 3 years. And because of that leadership, one of the great results is that more Americans will have more lifetime income options to ensure that they do not run out of income in their retirement. Of course, we all want this progress to continue, and we're concerned that the DOL fiduciary rule does the opposite. Clearly, from the opening remarks, the chairwoman and ranking member cite important data that outlines and articulates the retirement security gap that we face in this country. I'll add a few more data points for the record. We are at a point now in 2024 to 2027 that a record number, the largest number of Americans in our history, will turn 65. In this period from 2024 to 2027, 4.1 million Americans will turn 65. That calculates into 11,200 people per day, peak 65, if you will. Many of these folks lack sufficient protected income in retirement and face financial insecurity. Other data points, in today's workforce, 3 out of 5 small employers, those with 99 or fewer employees, rely on life insurers for employment-based retirement plans, and more than 15 million annuity-based IRAs held by individuals. Despite the fact that 82% of full-time civilian workers are offered an employer-provided workplace retirement plan, only 40% of part-time workers have access to workplace savings. Federal Reserve data show that Black and Hispanic savers have saving rates that lag significantly behind their white counterparts, and various sources affirm that women have inadequate savings for retirement, even though, as our actuaries tell us, we're going to live longer. I'm not sure we needed the actuaries to tell us that, but that is the fact. While Congress and the President have advanced policies, 2 different Congresses and 2 presidents have advanced policies to help close the retirement savings gap, DOL's fiduciary rule threatens to do the opposite. Expanding the definition of an investment advice fiduciary will hurt those who need retirement security most by creating a barrier between low and moderate income savers and financial professionals. DOL, as the chairwoman said, has been trying to do this since 2010 with 4 attempts. The 2010 rule was withdrawn in response to over 100 bipartisan House and Senate members of Congress. Their second attempt in 2015 was vacated by the Fifth Circuit Court of Appeals, and today the DOL is proposing a more expansive rule, even though the landscape has changed with additional enforceable consumer safeguards in place by the SEC through their regulation best interest and the National Association of Insurance Commissioners' best interest standard. These new standards are enforceable and they are real. The new consumer protections require a financial professional to act in the best interest of the consumer without placing his or her interest ahead of the consumer, all while continuing to provide guidance. And yes, there are 41 states that have already adopted this enhanced consumer protection that represents 77.6% of US consumers. And I can assure you, because we stay close to this at ACLI, the rest of the states are going to follow soon. If not 100% by the end of 2024, we'll be close to 100%. So it's not stopping with 41. The states have oversight that is consistent with the 1945 McCarran-Ferguson Act. The law entrusts states to regulate the business of insurance. The DOL has no authority to regulate the conduct of agents compensated solely for the sale of insurance products. So in closing, I'll just return to the most important point. The DOL's proposal will have a negative impact on retirement savers. This is fact. Before the Fifth Circuit vacated the 2016 rule, the response to the fiduciary-only regulation resulted in more than 10 million Americans' workers' accounts with $900 billion in savings. As Brad said, it's real, losing access to professional financial guidance, according to a 2018 Deloitte study. Life insurers have opposed the DOL's efforts to expand the definition of fiduciary, not because it would preserve a so-called profitable status quo, as some of our critics assert, but because it is unnecessary, ignoring substantive consumer protections that have been implemented in the last 3 years and would ice out Americans who rely on financial professionals. Thank you for this opportunity.
We thank you, Ms. Neely. Ms. Elliott, you are now recognized for 5 minutes for your oral remarks.
Good morning, Chair Wagner, Ranking Member Sherman, and members of the subcommittee. Thank you for the opportunity to testify on behalf of CFP Board in support of the Retirement Security Rule. I am Camila Elliott. I served as the 2022 chair of CFP Board, the professional organization that certifies more than 98,000 CFP professionals. CFP Board has a fiduciary standard that applies to all financial advice, including one-time sales recommendations. CFP professionals work for broker-dealers, investment advisors, and insurance companies. They have shown that any financial professional who wants to act in their client's best interests can do so. I am here because moderate-income Americans saving for retirement should have the same access to best interest financial advice that wealthy Americans enjoy. I am here because moderate-income individuals are the people who most need to make every dollar count. I am here because I believe that if the rule is adopted, moderate-income Americans will gain, rather than lose, access to retirement advice that is in their best interests. The rule does not prohibit financial professionals from earning commissions. Actually, most CFP professionals earn commissions. And my firm, headquartered in Atlanta, Georgia, provides financial planning with a focus on middle to high income clients. And we are all fiduciaries. We provide advice that our clients need at a price they can afford and in their best interests. We primarily support communities of color, offering various fee models and no minimum account balances. We are not the only firm that does this. Advisors all over America serve moderate-income retirement savers with best interest advice. Retirement savers want to work with someone they can trust, but that trust is too often misplaced. Financial professionals can take advantage of regulations that do not require them to operate as a fiduciary. Financial professionals can be paid handsomely for advice that is not in the investor's best interests. And financial professionals should not be allowed to make recommendations that compensate them well, but burden the client with excessively high fees, unnecessary risks, or harmful illiquidity. Too often, I have encountered situations where retirement savers did not receive advice in their best interest. For example, I met recently with a woman whose former financial professional recommended that she use her modest retirement nest egg to buy an insurance product that wasn't right for her. Had she invested in a diversified portfolio and a qualified retirement plan, she would now have tens of thousands of dollars more in accumulated retirement assets, money that could have gone a long way in her retirement years. In another case, a 48-year-old was sold a fixed annuity with an interest rate of less than 2.5% and a surrender period of 7 years. This means that for 7 years, she will receive a less than market rate return unless she pays a penalty of what represented about 60% of her retirement assets. The person suffered substantial financial harm from advice that was not in her best interests. And unfortunately, by the time she found me, it was too late. There are severe consequences for conflicted advice. Over time, small differences lead to enormous losses. For some, this may mean having to retire much later. For others, this may mean not having enough money to spend on retirement for things like health care, medications, and ever-increasing housing costs. Workers shouldn't have to work longer because their financial professional did not act in their best interests. Retirees shouldn't be unable to afford medicine because their financial professional was looking out for themselves. The wealthy receive financial advice that is best for them. Those with moderate incomes should be treated the same. On behalf of the CFP Board, we support the Department of Labor's Retirement Security Rule. And thank you, and I look forward to your questions.
I thank you, Ms. Elliott, for your testimony. And we'll now turn to member questions. I recognize myself for 5 minutes for questioning. Mr. Berkowitz, much has been said about the SEC's regulation best interest. Could you discuss the relationship between the DOL's proposal, new proposal, and Reg BI? The DOL claims the proposal is necessary to fill, quote, loopholes and gaps in the existing multi-jurisdictional framework of regulations. Is there evidence that such gaps actually exist and are being exploited to harm consumers?
Thank you for that question, Madam Chair. We do not believe that there are actual gaps in the regulation that are being exploited to harm retirement savers. The SEC adopted Regulation Best Interest in 2019, and it imposes a very robust best interest standard that requires all financial professionals subject to the SEC's jurisdiction to put their clients' interests first, to not make recommendations that line their own pockets at the expense of their client. These are very strong but fair and workable rules that are being actively implemented, actively enforced, and effectively protecting the consumers that need protection in those circumstances. What the Department of Labor is attempting here with this proposal is not to fill a gap, but to create a perception of a gap by criticizing the ineffectiveness of the SEC's Regulation Best Interest, which we completely disagree with, and then positing that they are somehow uniquely positioned to insert themselves into the SEC's jurisdiction to fix what the SEC apparently did not do well enough for the department's standards.
So the proposal effectively, it does not address any kind of gaps in a workable manner.
Not that we can see.
The DOL has claims also that anyone who is already complying with Reg BI should have no problem with this proposal. Do you agree?
Not at all. There are significant and extensive conditions built into the exemptions within this proposal that would go well beyond the requirements of Regulation Best Interest, extensive disclosure obligations beyond what the SEC determined to be necessary and appropriate, draconian disqualification provisions that would drive people to leave, force them out of the business for a decade for totally unrelated activities, and a host of other issues.
And costs, a lot more.
Significant costs.
Mr. Cadin, in the rollout of the fiduciary rule, the DOL and the White House characterized the compensation your members received as junk fees. Can you explain how your members are compensated and how the administration is wrong to characterize their compensation as junk fees?
They are compensated both by fees and through commissions. Both are appropriate compensation models that provide consumers with choice. I think the department is on an ideological crusade over the last 13 years to effectively ban commissions. That's why they continue to come back and back and back with regulations that are so punitive that it will literally make it impossible for our members to do their job.
Ms. Cadin, the average 401k balance in my district, Missouri's 2nd District, is around $100,000. If my constituents were to come to one of your members seeking to roll over their 401k into an IRA, how much would a one-time rollover cost them now versus after this proposal goes into effect?
Well, look, I think the kind of prevailing market is, 1% on assets under management. That's typically what asset gathering and asset management costs from our members and lots of other professionals. And I think that the challenge that your constituents would have, and all of your constituents would have, is finding representatives of the profession to actually do that work after this rule goes into effect, because I think the minimums would clearly go up because the cost and regulatory burden is so high.
So lower and middle income constituents would say 15, 20, 25,000 in their account. They'd be out of luck.
There's a reason why, Madam Chair, 10 million Americans lost access to advice after the last time this rule went into effect, including Brad.
10 million Americans.
10 million Americans lost access to financial advice after the last time they tried to do this rule.
It's been shot down 4 times, I remind. Should this Biden proposal go into effect, would that person, meet the minimum asset thresholds in any way, shape, or form that we expect financial professionals to impose? Sounds not likely.
It's, again, costs will go up, minimums will go up, and Americans will lose access to financial advice that they desperately need.
I have additional questions, but my time has expired. So I now recognize the ranking member, Mr. Sherman, for 5 minutes for his questions.
At least one of the witnesses testified that retirement savings are important, therefore this rule is bad. I think that's a non sequitur. Throughout savings by ordinary middle-class Americans, they have best interest protection. I've got an account with Merrill Lynch. It's not an IRA or retirement account. The SEC gives me best interest. ERISA accounts administered by the employer, best interest protection is there. And in 40 out of the 50 states, the National Association of Insurance Commissioners provides best interest protection. So it's by no means clear that best interest protection prevents one from making good investments, since the vast majority of the savings of middle-class Americans enjoy that protection. Though there are just a couple of exceptions, and this rule purports, and I say purports, to simply cover those additional areas. But clearly, most of our witnesses don't like the regulation, and so my first question is one I'd like you to respond to for the record. What changes should be made to this regulation so that its effect is to provide the same level of best interest protection that I have, or everyone has in their regular securities account, that the National Association of Insurance Commissioners seeks to provide, and that already applies to ERISA accounts? Because I don't think that anyone is objecting or could object to the idea that in a society where almost all accounts have best interest protection, that there should be a few that don't. I'll point to an AARP poll on financial advice for retirement plans conducted just last month, which found that 90% of adults 50 and over believe that financial professionals should be required to provide advice in their best interest of the investor. Is there anyone, I'll ask for a show of hands, that believes that you shouldn't be required to provide advice in the best interests of the investor? No hands went up. I'll comment for the record. Ms. Neely, you don't think that best interest should apply?
I was listening to the double negative. I guess I should let you finish, sir. I was just going to say, we do support.
I just wanted, I've got a limited time. Without, hopefully there being no objection, I want to enter in the record this report from AARP on the hearing that we're having today.
Not objection.
Okay. Now, Ms. Neely, I will make one comment. You talk about how annuities provide guaranteed income for life, but they aren't, for the most part, inflation adjusted. No American should underestimate the ability of Congress to cause inflation, not just what we've had now, but what we saw in the 70s and 80s. And your industry doesn't really provide inflation-adjusted annuities, and there isn't a single company that provides an inflation-adjusted annuity starting at age 80. That is to say, a longevity policy that's inflation-adjusted. So this security that I hope you're advising your clients, this is secure income, but $100 might not buy you anything 30 years from now. Let's see. Well, does Ms. Neely, is there a problem with providing the same? Well, if we just had the Department of Treasury require that the same standards that apply in 40 states with the National Insurance Commissioners apply to all 50 states, would that be a problem for your industry?
Well, we do support, just to say it again for the record, a strong best interest standard, which is what we have thanks to the Reg BI and the work.
But there are a few areas, as I said in my opening statement, where that strong standard doesn't exist. Do you support extending it to those areas too?
Well, we do, which is why I would predict that most of the states will have adopted it by the end of the year. So, but what I would further say is that what the Department of Labor has proposed goes beyond that.
And that's why I've asked for the written comments of everybody on this panel. How do we get these regulations to do what I think we all agree, and that is we should have the same protection across the board that we enjoy in most of the economy. With that, my time has expired.
Gentleman yields back. The chair now recognizes the gentleman from Oklahoma, Mr. Lucas.
Thank you,
5
Madam Chair.
minutes.
And thank you to the witnesses for appearing before the subcommittee today to discuss the consequences of the Department of Labor's fiduciary rule. First, I'd like to discuss how we arrived here. The Department of Labor proposed a fiduciary rule back in 2015, which was finalized in April 2016. The Trump administration delayed major aspects of the rule before the Fifth Circuit Court of Appeals vacated the rule in 2018. At that time, the court held that the Department of Labor overstepped its authority. Mr. Campbell, could you explain and expand on the similarities between the rule that was vacated and this proposed rule?
Thank you, Mr. Lucas. That's an excellent question because the Labor Department says this time we've done it differently. This time we've narrowly tailored our proposal to correspond to the Fifth Circuit's ruling. But if you look at what the proposal actually does, yes, they use different words to describe the test, but it applies to exactly the same universe of people. In fact, it even applies more broadly because the current proposal doesn't contain some of the exceptions that were in the 2016 proposal. So instead of saying any transaction involving a plan or IRA is fiduciary, which they did in 2016, they now say that any transaction where you made an individualized recommendation in their best interest is fiduciary. For financial professionals, those are exactly the same thing. They are making best interest recommendations in most cases already. And so DOL's approach has the same scope, affects the same people, and is not more narrowly tailored.
Along that same line, Mr. Berkowitz, could you also discuss how this new proposal is likely to be viewed by the courts?
Yeah, I mean, having reviewed the Fifth Circuit decision, and thank you for that question, Congressman, having reviewed the court's decision, I think that they are going to find many very significant similarities between what the department has proposed here and what they have indicated in their decision in 2018 was beyond the DOL's jurisdiction. There is very clear recognition throughout that decision of the primacy of the SEC and the state insurance regulators in regulating the conduct of people over whom they have jurisdiction, and the department here has inserted themselves where they are not appropriately regulating. And there's really, as we have said, there's no need for this because we have this very robust and effective framework.
A broad bipartisan policy goal, I believe, is to encourage workers to save for retirement and for families to accumulate savings, and the SECURE Act and SECURE 2.0 are testaments to this. Continuing with you, Mr. Berkowitz, could you outline how this rule by the Department of Labor will adversely impact retirement savers and work against the bipartisan goal of increasing retirement savings?
So, yeah, thank you for that question. I would say the choice of who you're going to work with as a financial professional to help guide you in making these very important decisions is a highly personal choice. Individuals decide who they're going to work with based on a wide variety of factors. This regulation is going to take that decision out of the hands of many individuals and force them to narrow the universe of people that they could potentially work with to those who have decided that they are willing and able to take on the obligations associated with fiduciary status, which are very, very burdensome and very robust. And as a result, many of those are going to be no longer available to retirement savers. So they have to now find somebody else to work with, and there's going to be a much smaller pool to choose from.
Mr. Cadin, I'll ask you a very similar question. How will this rule make the job of helping families meet their saving goals more difficult for financial professionals in the time I have left?
It will make it literally impossible for thousands of professionals to serve millions of families. Literally impossible. The regulatory burden, I had a member, Jacob from Indiana, tell me the regulatory burden was more disruptive to his business than was COVID. And all he's trying to do every day is get up and help families in his community save more, plan more, be ready for retirement. So, the notion that we're going to add duplicative, harmful regulatory burdens on the profession whose objective is to help families save and be more prepared for retirement, the notion that we're going to put more burden on them and they're still going to help, it's just simply not the case. So I think there's a reason why 41 regulators across the bipartisan spectrum, members of Congress of both parties, the SEC, FINRA, everybody sort of agrees on best interest, the DOL is the one group out there with a fiduciary-only approach.
Thank you, Madam Chair.
Chair now recognizes the gentleman from Georgia, Mr. Scott, for 5 minutes.
Thank you, Chair Wagner. Mr. Berkowitz, in 2015, 93 Democrats, including the ranking member and 3 others on this very subcommittee, sent a letter to then Labor Secretary Tom Perez to express significant concerns about the then pending fiduciary proposal that was ultimately accepted in 2016. In that letter, we urged the Department of Labor not to move forward with any fiduciary rule that would, 1, limit consumer access to advice, 2, disproportionately impact low and middle income communities, among others. Now, Mr. Berkowitz, does the 2023 fiduciary proposed rule align with these principles as outlined by my Democratic colleagues in that letter?
Thank you for that question, Congressman, and no, it clearly does not. We believe that by forcing all financial professionals into fiduciary status, it will again cause millions to lose access to the products and services they need.
Well, on Monday, my good friend from Arkansas, Congressman Hill, and I sent a letter to Acting Secretary Sue and Assistant Secretary Gomez, which was signed by 50 bipartisan members, urging them to withdraw this latest misguided version. And Chair Wagner, I'd like to, can you give me that letter? Chair Wagner, I'd like to insert this record, insert our letter dated January 8th, 2024 into the record. All right. Does the DOL proposal allow foreign courts to make determinations about on individual actions unrelated to their businesses that would impact an entire financial institution's ability to use certain prohibited manners?
Yes, it does include that. And just as an aside, Congressman, I want to thank you and Congressman Hill for your leadership in producing that letter and submitting that to the department. To answer your question, the proposal does include a very, very draconian disqualification provision that would rely and defer to federal foreign courts in countries that may not have all of the same due process protections that we enjoy here, and could be unrelated to the provision of retirement advice.
And we did this because the SEC, and not the DOL, was the best place in our government to study how we can effectively harmonize standards, placing the least burden on not just the industry, but also the everyday retirement savior. I feel very passionate about this issue, Mr. Berkowitz, because I started investing in the stock market as a class project in the 6th grade at Scarsdale Junior High School in New York. And our class project was to go earn our own money and then do our research, and then take the school bus from Scarsdale down to the New York Stock Exchange. And we bought stock, and I've been buying it ever since. It has been the foundation of my own, being able to start my own business, buy my own home. And so this is why I feel very passionate about this. And it's deeply concerning to me that the Labor Department might again create a regulatory regime with such harsh consequences. No, we got to find a way to make it easier, working with families to create and build wealth, much like I did, because of proper investments. Thank you, ma'am.
Gentleman yields back. My goodness, sixth grade, that, the time value of money must be amazing. I'd love to see that portfolio.
At Fox Meadow Elementary School,
God bless.
got my start.
The chair now recognizes the gentleman from Texas, Mr. Sessions, for 5 minutes.
Madam Chairman, thank you very much for holding this hearing, and to each of you who have joined us today as witnesses. I must say that, Mr. Scott, on this side of the aisle, we, with great confidence, I labeled you as Exhibit A for why we are doing this today. And I shouldn't do this, but I'm going to take a second and tell you, when I was in sixth grade in Waco, Texas, at Providence Heights Elementary School, I'm a Republican. I come from a Republican household, but I, in school, was asked to do a book report on whatever I wanted to, and I chose to find out what was the most wealthy city in America per capita in 1966. Somebody could look it up and find out I'm wrong, but the answer that I received was Milwaukee, Wisconsin. So I went and did my book report on Milwaukee, Wisconsin, and found out that at least what was printed at the time was the workers there had regular jobs. They went to work every day. They had a stable environment in a city. Second characteristic, that they intended to, because I guess that's where beer was and probably still is a good industry. I then found out that they then saved their money, and they were taught how to save money and prepare for the future, not just the future, their future, but also the future of the country. That they had a stockbroker who was there, who advised them, and one person talked to another, who talked to another, and they were pushing the stock that was called IBM. And that IBM, in its infancy back then, was producing wealth as an industry. And that was the book report that I gave in sixth grade about Milwaukee, Wisconsin, about savings, about planning for your future. And then there were several articles at the time. Now, I'm sure somebody is going to go and look this up and tell me I was wrong by some margin, but Mr. Scott, I too received an education in school where we talked about our future, where we talked about savings, where we talked about capitalism, where we talked about being proud of who we are. The people who are here before us today represent industries that I have bought into. Ms. Neely, I have been a proud supporter of the insurance industry because I have used them. And notwithstanding, perhaps not everything is perfect about the industry, but I knew what the rules were. And those rules that I was willing to buy into, I played out. Each of you, Mr. Berkowitz, I too play in the stock market. I too put my money in and try and pay attention, and I also have a professional that I talk with who does it for a living. And I'm not I don't have it made. I've never missed a day of work ever in my life. But it's part of capitalism, it's part of America, and if the government really handles its business correctly and lets the free enterprise system work and the rules and regulations that are balanced, the next generation will receive the same advantage we did. I wholeheartedly believe that what you hear today is a story where we're also complimenting each of you for standard bearers of not just an industry, but a free enterprise system and capitalism, where people can have confidence. I think the world recognizes America gets it right. And it doesn't mean everything's always right. I think Congress causes more problems sometimes than the advantages it creates. But with that said, I want to thank each of you for being here. I think our young chairwoman held this hearing because she too views it the same way you do, and that is where there's a balance in a marketplace, it's an advantage for tens of millions of people. And when you have an activist government who keeps retrying to kill free enterprise and capitalism, you have to stand up and fight it. So I just really want to do the same thing Mr. Scott did and say, capitalism works, free enterprise works, and thank you for being a part of that. Madam Chairman, I yield back my time.
This very young chairwoman.
Absolutely, the young
Please,
chairwoman.
the gentleman yields back and recognizes the gentleman from California, Mr. Vargas, for 5 minutes.
I thank the very young chair for the courtesy and also the ranking member for this hearing. I agree with Mr. Sherman that we need the same level of best interest protection for everybody, no matter how they invest. I think that's very important. And I do think that we have a bipartisan goal of having Americans save for retirement. I think that's what we have to do, but I would be remiss if I didn't talk about workers themselves. If you take a look at the worker participation rate in our country, it's been going down significantly for years. And unless we have more children, or unless we allow immigrants to work, we're going to have a real problem on our hands. And that's why I think it's very important. Unfortunately, immigrants have been demonized in such a way that unfortunately they don't have the opportunity to work. I would remind people of Matthew 25 when Christ said very clearly, when a stranger lives among you, that's him too. And also in Leviticus, when an alien lives among you, treat him as you would treat your native born. Love him as you love yourself, for you two were strangers in Egypt. And again, I bring that up, and I would be remiss if I didn't, because I think it's important for us to take a look at that long term. All that being said, Mr. Campbell, you lost your advice, and you were about to tell us a really good story, but your time ran out. You did work for the government for a little bit, and so I give you a minute to explain what happened.
Well, yes, indeed. So I have, amongst my retirement savings, fortunately it was not my only retirement vehicle, but I had a relatively small balance IRA. I still do have this IRA. And I had placed it with a broker-dealer on a transactional commission basis on purpose, because it's a long-term savings vehicle. I don't trade frequently, and paying an annual fee would be an inefficient way, an inexpensive way to get those services. Because the account balance was too small, right after the 2016 rule went into effect, and it was in effect for about a year and a half before the Fifth Circuit vacated the rule, my broker-dealer called me and said, look, I'm sorry, my firm is no longer going to allow me to make recommendations to you in this account. You're below the size that we're going to be able to do that for. And as a result, we'll take your orders, but we can't help you with recommendations.
Okay, and clearly that's what I know the number of you believe. So I appreciate that, okay. But I do want to ask you this, or for anybody, I mean, when the issue of best interest went up, the question Mr. Sherman asked everyone except for you, Ms. Neely, said yes, and I think you did it mistakenly because of the double negative nature of the question. But I do think that you all believe that there should be a best interest of the client, of the investor. Is that not the case?
Absolutely.
And I think,
Absolutely.
Ms. Neely, I don't want to put words in your mouth, but I think that you said that these other states that have not yet taken up that standard should, and that they probably will, right? So, Ms. Elliott, what do you think? Is that enough, or is it not?
I don't think, I think having financial professionals work in their best interest is a requirement. For me, personally, in my experience, and Mr. Campbell, you can always call Collective Wealth Partners. We're always happy to help you with your IRA.
There you go, right there.
We do not have accounts.
Solving problems right here.
But one of the things that I think is important is, I've seen the harm done. And I want to address a couple of things that were stated, is that there's belief that it would remove access to competent planning for low and middle income Americans, and that's not the case. One of the things I want to share and put on record is that the CFP board added in 2018 that all professionals must act under the fiduciary standard. We've had an increase of 23% more CFP professionals since that was enacted. So more and more financial professionals are joining and helping American savers be able to retire.
Okay. Well, would anyone else comment about that?
I think there's a difference between a best interest standard and a fiduciary-only approach. And I think the best interest standard that we are all in violent agreement with is 41 states, the SEC, the NAIC, FINRA, and as Susan said, we fully expect and are actively working to get 50 states to adopt a best interest standard. But a fiduciary-only approach basically has the practical effect of banning commissions. And even the CFP board's the comments that they've put out recognizes that the NAIC Model Act requires the producer to put the interest of the consumer first. So it's a question of whether it's a practical standard that still provides consumer choice.
My time's up. I thank the chair, the very young chair. Thank you.
Gentleman yields back. The chair now recognizes the gentleman from Michigan, Mr. Huizinga, who is also the chair of the Subcommittee on Oversight and Investigation, for 5 minutes.
Thank you, Madam Chair. I'm going to start with Mr. Campbell here. You had worked at the Department of Labor, 06 till when?
I was at the department from 01 to 09, but I was the assistant secretary from 06 to.
Okay, got it, okay. Where are the lawyers? Where the hell are the lawyers giving the DOL, much less the SEC, advice that they're coming back at an issue that the courts in the Fifth Circuit have already ruled on? I mean, they tried this in 2015. I happened to be chair in 2017 of this subcommittee and ranking member in 2019, where we had hearings on these. And I went back over and looked at my comments back then. And it's like Groundhog Day. Here we are again. And I'm curious how this is working internally, real quickly. I mean, it's a little rhetorical, but I do not understand how they can look at what has come out of the courts and take another run at this.
I would agree with you. I think the Fifth Circuit decision was clear, unambiguous, and not particularly vague as to you don't have the authority, Department of Labor.
Maybe those lawyers are off trying to track down hackers to their X accounts and all the other stuff, but they certainly don't seem like they're giving very good advice. I will, Ms. Elliott, because she brought it up, I will note that the research that I looked at, her taking over your IRA is going to cost about $250 an hour, according to her firm, correct? Yeah, she's nodding her head.
Well, that is one of the various fee models. But
okay, various models. Well, correct. So let's just do the addition on this. I happen to have a brother who was in the industries, now in real estate. I used to be in real estate. I made a living on commissions. So to put together any kind of financial plan for individuals is about $4,500. I got people in the 4th Congressional District that are coming in with $4,500, not having to pay someone $4,500 to go get expert advice. And Ms. Elliott, you've got a stellar background, Vanguard and a number of other places. I'm not assailing that at all. What I am saying, though, is this rule is going to take options away from people. I have a small IRA from when I was self-employed as a realtor, both a Roth and a regular. So, Mr. Berkowitz, in 2019, the SEC concluded that the Department of Labor's fiduciary role caused a, quote, significant reduction in retail investor access to brokerage services. Is this going to have the same impact?
It absolutely will, Congressman, and thank you for that question. There's no question. This is a fiduciary for all approach, which is what the department has contemplated here, is very, very different from the best interest standard that has been talked about that everybody here agrees with, and it will 100% cause people to lose access.
So, Ms. Neely, you talked about the $7 trillion savings gap. I think somebody, it was Mr. Cadin or Campbell, talked about that as well. I will note that that by doing nothing in retirement, and with our Social Security system. The Social Security trustees have said that by 2033, there will be an automatic, by law, 23% cut to their benefits. 23% cut. So that $7 trillion is going to grow if we do nothing as a Congress, which is unfortunately the norm around here. We're trying to change that. But 2011, Barbara Roper, who now ironically works for the SEC, and Chair Gensler, who was with the Consumer Federation of America, testified before this subcommittee that a $2,000 a year investors are, quote, her quote, not that enticing a market, and there are not a lot of fee-only financial planners or fee-only advisors who are going to step in and provide those services, close quote. So I'm curious, Ms. Neely, if you want to address this, how do we get to these lower income? Because that is one thing that we agree on, Ms. Elliott, is you talked about the moderate income investors, not so much the low. You pulled that out of your written testimony to your verbal testimony, but you mentioned the moderate income investors need greater access. We all agree on that. Ms. Neely, you can finish us up here.
Well, I think it's, you're talking about financial inclusion and how are we affirmative and purposeful about reaching out to people where we know there are specific gaps, which we talked about in our testimony. I will use my own double negative. We don't do that by eliminating choice. We support a best interest standard. We support a fiduciary standard. What we don't support is a fiduciary-only standard.
Thank you.
Gentleman's
I
time
yield
has
back.
expired. The chair now recognizes the gentleman from Illinois, Mr. Cadin, for 5 minutes.
Thank you, Madam Chair. I appreciate everybody coming here. I often feel like the most interesting things on this subcommittee are always the same. It's the tension between investor protection on the one hand and market access on the other, and you push too hard for one, you squeeze the other, and it always goes both ways, and I'm very sympathetic to both sides of that. I'm also sympathetic for purely personal reasons. My parents both grew up in rural Colorado, and I remember going out to Christmas out there when I was a kid, and my great aunt made her money running a little life insurance business in town. And every year for Christmas, I got a $50 savings bond and a box of gumdrop cookies. And that's sort of my stereotype of like, small town life insurance brokers, maybe not the most sophisticated suite of products, but a good understanding for what this particular client really needed, which was the gumdrop cookies. I want to start with you, Ms. Elliott, and I want to try to make sure I get some time to get both perspectives here. But can you just walk through? You'd alluded to some of this in your opening testimony, but I want to get your thought on what the gaps are in the current rules, and particularly the five-part test, the 1975 test from ERISA, of where some of those gaps are that you see we might need to work a little harder on investor protection.
Sure. One of the gaps I notice is the removal of the one-time sales recommendations that is currently in the rule. For many Americans, they don't have a financial advisor that they can access on a routine or consistent basis. Many Americans reach out to a financial advisor during a key life event. One is if they're leaving an employer, as was mentioned earlier, there's a death in their family, they're planning to retire, like an analysis to ensure they can retire safely and comfortably. And that removal of one-time advice currently now, it does a lot of harm for clients. If they're reaching out to a professional that they believe is working in their best interests and is selling them a product that's doing them long-term financial harm that impacts us and Americans in the US in a myriad of ways, that exception is very significant and needs to be addressed.
I picked 75A because that's, I think, when the rule was written, but also because that's about when I remember going back and meeting with Auntie. Talking about like this, the world has evolved a lot since then. You mentioned best interest, and I think a number of people there's been a lot of head nodding that, obviously everybody wants to look out for best interest. When I've spoken with some of the life insurance agents back home, a lot of them say this is duplicative with Reg BI, but my understanding, and correct me if I'm wrong, Ms. Elliott, is that Reg BI only applies for the sale of securities, right?
That is correct. Reg BI only is related to securities. It does not include fixed products like fixed annuities and whole life insurance. So that's something that is often sold to low and moderate income Americans, and that at times can do financial harm.
Yeah. And again, maybe Ms. Neely, if you'd like to comment, are there areas where you think, I mean, these are old rules, these are almost 50-year-old rules. Are there areas where you think where you would agree that we could make some improvements, setting aside the current rule, where we can tighten it up to maybe close some of these gaps in Reg BI or to fix some of the ERISA rules where you'd agree with?
Well, I think the key is to look at what's happened not in 2016 or where we were in 2016, but what's happened in the last 4 to 5 years. It's not just Reg BI, it's the NEIC best interest model, 41 states on the way to all states. So we think that provides the appropriate protection while preserving choice and access to ensure that you've got financial professionals available at the price people can afford based on where they are on the economic spectrum. We will say for the record that we believe the current proposal from DOL is so expansive it just needs to be withdrawn and cannot be fixed.
Okay. Well, one thing just to mark, for the last 2 Congresses, I've introduced the SEC Disclosure Effectiveness Testing Act, which was basically focused on the fact that I think there was a RAND study done a number of years ago that people who sign all the disclosures under Reg BI, the vast majority of them can't define the difference between a broker and a dealer after the fact. And so basically to go through and say, like, if we have these disclosures for investor protection, let's at least do some market testing to satisfy ourselves that this is in plain English, that people understand what they're doing to protect them. I'm running out of time. If other of you have comments, let us know. I have a lot of confidence that Department of Labor will find a way to work this through. And I do think there's good people here, but I think let's acknowledge that there is some tension, there is some updating that's needed to be done, and make sure that we get comments into the record that try to strike that balance. Thank you, and I yield back.
Gentleman yields back. The chair now recognizes the gentleman from Arkansas, Mr. Hill, who is also the chair of the Subcommittee on Digital Assets, Financial Technology, and Inclusion, for 5 minutes.
I thank Chair Wagner for convening the hearing. I know when your alarm went off this morning, it was from Groundhog Day, it ain't you, babe, so that we get to hear about this topic again for the 9th year in a row. I want to say how much I appreciate the chance to work with Representative Scott as he leaves the room for the outstanding partnership we've had on this issue, helping retired Americans have good, affordable choice for their financial advice. And it is significant, I think, to all those listening and watching this hearing that once again 50 members from both sides of the aisle join with Chair Wagner in just talking about how dysfunctional it is for all the problems facing Congress that we're once again dealing with this topic. Madam Chair, I've got 2 letters I want to add to the record. Mr. Scott obviously put in our joint letter, but I have a letter from our former insurance commissioner in the state of Arkansas and letters from the chair of the Arkansas Legislative House and Senate Insurance and Commerce Committees.
Without objection.
Thank you very much. Needless to say, they're opposed to that, this rule, adding to the confusion for trying to provide investment advice around the country. And to the point made, which was a good point, that Reg BI is a SEC FINRA-related rule. That's true, but it's been noted in testimony that 41 states have acted too through their insurance commissioners, which deals with the idea of a fixed annuity product. And last time I checked, variable annuity products are considered securities, so they're covered by Reg BI. So I don't see the gap here, Madam Chair, other than perhaps the 9 states that haven't dealt with this issue at their state level. I won't belabor this point about the Fifth Circuit and once again the general counsels at the Department of Labor working on an interagency basis, basically defying the federal courts and drafting this rule again. I just don't understand it. It makes no sense. And I've sat on, in my executive branch tour of duty in my life, plenty of interagency meetings with lawyers telling us what we can and cannot propose. So let me start, Mr. Berkowitz, with you, just from a perspective. Am I right that there's no real gap here, that the Reg BI and the action by state insurance commissioners covers this concern about best interest for our clients, whether it's a securities-based product or an insurance-offered product?
100% agree with you, Congressman, and thank you for that question, and thank you again for your leadership on this important issue. Yes, clearly between the SEC's regulation best interest and the NAIC's best interest regulation, we believe that this does fully cover the entire population as it pertains to those products. So we don't think there's a need for anything further.
Mr. Cadin, you agree with that?
I absolutely agree, and I'd take it a step further. I mean, you're very eloquent, Congressman Hill, and Congressman Scott was, and really all the members on a bipartisan basis. I take it a step further, though. I think that you as elected representatives have a higher level of responsibility than the fine people that work at the Department of Labor.
Sure, I agree with that. I mean, this gets to the heart of the battle we have between the administrative state and the legislative branch.
And I would hope...
it's deteriorated over the years. This is just another example. And the fact that we are revisiting this in opposition to Congress's clear intent here over a decade post-Dodd-Frank being passed, and the federal court's ruling just means that we just have people doing busy work over the Department of Labor. But let's stay practical here. Is the framework managing conflicts of interest now, you think, post-2019 and Reg BI and the actions by the states?
The framework is working. We have to let it work. And I would take a step further and say, I think the bipartisan will of 50 members and majorities of both houses of Congress should defund the department's ability to implement this rule.
I'm gonna use my final time in conclusion. Everybody's been telling a story today, so I'll tell one. I've been registered in the investment business since 1986, obviously not registered now that I'm in Congress, and I grew up in a family of a mom and pop shop that helped families with their investments, and my dad died last October. He was 96 years old. And he said the most affordable thing for a retired person with savings is, obviously, to not take a fee every quarter. And so he was a great voice for 50 years in my life, rejecting fee-based management. He wanted it commission-based because once he got his investments squared away, he wanted to leave them alone. So I yield back, Madam Chair.
Gentleman yields back. And yes, not quite Groundhog's Day this morning when the alarm went off, but as I said earlier, another bite at the same rotten apple. So the chair now recognizes the gentleman from Missouri, Mr. Cleaver, for 5 minutes.
Thank you, Madam Chair. We've had a lot of time at home over the last couple of weeks, and most of us spend that time with constituents trying to get caught up on how they are thinking. I have a long-standing relationship with the AFL-CIO, the local president, and I'd like to focus on a letter sent to the administration and forwarded to me by the AFL-CIO. This is an organization that representing 60 national and international labor unions that jointly represent a whopping 12.5 million people. And the AFL-CIO, as many of you probably know, would think, they support the proposed rule in full. And I clearly understand that the overarching goal of labor is to achieve a better life for working people, including making sure that the workers have a financially secure retirement. Now, these are people that are teachers and miners and firefighters and farm workers and bankers, like my colleague, and engineers. And so I try to take everybody's feedback very seriously. Ms. Elliott, the AFL-CIO asserts that the DOL makes a compelling case for updating the current rule. Among a number of the considerations when the DOL promulgated the current definition of an investment advice fiduciary in 1975, IRAs are only recently been created, and the 401k plan did not even exist do you agree that there's been an evolution in the retirement income landscape that has created significant regulatory gaps and loopholes?
Thank you very much, Congressman Cleaver, for that very astute statement and for sharing that letter from the AFL-CIO. Many Americans are up to themselves to take charge of their own retirement. Unfortunately, very few Americans have a defined benefit or pension plan. And I think we all can agree in this room that many Americans don't have a strong amount of financial literacy. I applaud the various congressmen that stated their experience in investing since they were in the 6th grade, but that is not common for most Americans. And when Americans do seek out financial advice from a professional with help on how to retire, they make the assumption that that person is working in their best interest, that that person is putting their needs above theirs and is ensuring that they have retirement security. And so I think that landscape has changed, and I think that how we go about creating rules and laws to ensure that we're protecting all Americans, not just wealthy Americans with best interest, is really important to help support low and middle income American savers.
Thank you very much. I'm interested in everyone's response on this. Obviously, I don't have time, but I'm wondering if you agree that most American workers and retirees have not acquired an expertise that is required for a sound investment, and so they're turned to professionals. All of us agree. Now, do any of you believe that that moderate income investors need to receive advice, and sometimes the advice is not in their best interest? Does anybody not agree with that?
Yeah, I think we would all agree that Americans need financial professionals to provide advice, that they should operate in the best interest of the person they're advising. And I think the place where we disagree is that we believe between Reg BI and the states that have acted that there is very substantial consumer protections in place.
Thank you. If I had 10 more minutes, we could get to your response. Thank you, Madam Chair.
Gentleman yields back. The chair now recognizes the gentleman from Wisconsin, Mr. Steil, for 5 minutes.
Thank you, Chair Wagner. The fiduciary rule would restrict Americans' access to quality retirement advice at a time of high prices and volatility. It would harm retirement savings, and the risk here isn't just theoretical. In response to the 2016 rule, companies began to take the very steps we're warned about today, raising minimum account sizes, reducing face-to-face support, and cutting offerings. And making matters worse, the Biden administration is committed to fast-tracking this rule, ignoring public input, and likely, in my opinion, violating the law in the process. Under the Administrative Procedures Act, agencies are required to make decisions based on the comments received and are not permitted to prejudge the results of the comment period. This is exactly what seems to be occurring. President Biden openly endorsed the fiduciary proposal exactly as proposed on the day it was proposed. He's effectively prejudged the outcome of the process. Showing further disregard for stakeholder input, DOL refused to extend the comment period beyond a mere 60 days. The Department of Labor has said that they've heard the industry's arguments before and really don't need to hear more. And to make matters worse, the comment period was carefully placed during the height of the holiday season, and the hearing was held before comments were finished. Again, this is an agency action to achieve a predetermined outcome that treats the core requirements of the APA as formalities. This should not be partisan. 8 Democratic senators made the same arguments in a letter just last month, arguing that the flawed process is inviting legal challenges. If I can start with you, Mr. Campbell, and I'll come to you, Mr. Berkowitz. Do you share my concerns about the process in which DOL has pushed this rule forward? And is the rulemaking process differed from more normal rulemakings in the past? Start with you, Mr. Campbell.
Yes, sir, it does absolutely differ. And I do think the process is not compliant with the Administrative Procedure Act. In particular, holding the administrative hearing in the middle of the comment period denied a meaningful opportunity to comment on the rule.
Have you seen that before, where they've held that in the middle of a comment period, or did that seem rushed to you?
I have never seen that before by any agency, much less the department.
What would be the purpose of that?
Presumably to rush the process by not waiting until after the 60 days expire to then have 2 days of hearing.
So an attempt to drive a predetermined result?
That's the only rationale I can conceive of for why they would do it that way.
It'd make it
Because otherwise
more difficult for these comments to come to fruition, to be able to get thoughtful input due to the timeline, not just the mere 60 days, but also putting that during the holiday season and then jamming in the hearing during that process?
I think all of those are irregular. Not all of them are necessarily violations of the APA, but I do think the hearing in the middle of the comment period, I think that is a violation. I think it's inconsistent with DOL's own rules, its own procedures for promulgating exemptions.
And so let me jump to you, Mr. Berkowitz. Do you agree with that line of thinking?
Yes, absolutely. And I also have never seen anything like this in terms of the speed at which this is moving and the order in which they're doing things and the utter disregard for the need to take more time to digest and fully evaluate a incredibly extensive and complex proposal.
Do you think that they're trying to drive a predetermined result?
As Mr. Campbell said, it certainly seems that way.
Mr. Cadin, you're nodding. Do you believe they're trying to drive a predetermined result?
There's no question about it. I testified before the Department of Labor, and I said this rule is offensively framed, substantively bad. I received 0 questions, 0 challenges to any assertion I made. We've met with the department multiple times. They make no reference to any of the input and perspective we provided.
Let me jump to you, Ms. Susan Neely, if I can. As I'm thinking about people from my home communities, right, Janesville, Kenosha, southern suburbs of Milwaukee, the real-world implications are what? Somebody who has a smaller amount of savings, doesn't have millions of dollars, comes in, they want to get thoughtful advice. What does this rule do to them?
The average income of an annuity holder is $76,000. The median income for the U.S. is $68,000. This would preclude that very important middle-class, working-class segment of the market from getting the advice from a financial professional that they need and deserve.
Thank you all very much. Thank you, Madam Chair. I yield back.
Gentleman yields back. The chair now recognizes the gentleman from Pennsylvania, Mr. Muser, for 5 minutes.
Thank you, Madam Chair, very, very much. Thank you all. I think we've said a lot here, and I think if anyone was listening closely enough, we see that this rule will be quite detrimental to those it's pretended to protect. But before I begin, Madam Chair, I would like to enter into the record of this December 2023 survey from the National Association of Insurance and Financial Advisors entitled Impact of the Proposed DOL Fiduciary Only Rule on NAFA Members.
Without objection.
Thank you. And just a quick perusal of this will show you that this organization of thousands of members, 70% of respondents currently have no minimum asset requirements for service. This rule goes into effect, 28%, only 28% would not have a minimum asset requirement. 92% feel they will see increased costs in providing disclosures. 91% will increase cost in record keeping. 90% will increase cost in hiring and training. So what we're being asked here by the government is to increase services, increase standards, lower prices, and somehow or another that plan won't backfire. Okay, so clearly many of us who appreciate supply and demand and capitalism see that this is going down the wrong road. Of the 36 NAFA members from Pennsylvania and 3 from my district, again, prevented the stark realities regarding the impacts here. And the survey does indicate that the proposed rule would drastically alter the way financial professionals operate, leading to reduced product offerings, increased operational costs, and again, back to the including minimal asset requirements, as we're hearing, could be very problematic to low-income and low-asset investors. So, Mr. Campbell, you've mentioned a few views here in line with the problems that will come from this rule. So if you have 67% of the financial professionals anticipate that they will have to stop or reduce sales of certain products, could you offer a couple of specific examples as to what might not be offered to those in that lower asset class?
Well, I think very clearly one of the issues, as they identified, is that if you don't have enough money that we can profitably offset the expenses of serving you, we're going to have to require you to have more money or we can't serve you. That's just, as you say, that's supply and demand. It's a logical reaction. If I have to spend more, if it costs me more to provide advice to you because of the compliance burden, and I think it's worth addressing a misperception. This is not a gap filler rule that just fills up where best interest isn't in place. DOL is putting out a rule that actively replaces Reg BI with respect to these folks, actively replaces the state rules. Both apply at the same time. So that advisor is going to have to comply with Reg BI in all of its detail and the DOL rule in all of its detail, even those are already a best interest standard in place. So that is extremely expensive, and that will cause those minimums to rise and reduce access.
It's really two different classes of services being requested. One has a comprehensive fiduciary rule of overall wealth management, and the others are brokerage, where you're very specific about purchasing a stock or other investments, and they're both available, but they're in different categories, such as a convenience store versus a big box store. I mean, this is similar to requiring a convenience store to having the same prices as the big box store, and as well having operational changes where they have to stay open 24 hours a day by chance if someone comes in at 4 o'clock in the morning. It's just a heavy-handed approach, which again would backfire. Mr. Berkowitz, as I stated earlier, 90% of NAFA respondents expect higher costs for hiring and training staff. What do you think the impact of that would be on the services offered to consumers?
Thank you for that question. I'll actually just use myself as an example of how this would have impacted me, because I think that thinking back to early in my career, I had an initial job where I luckily had access to a 401k, left that job for family reasons, ended up moving to a new position, and was introduced to a broker-dealer who offered to help me move into a rollover IRA. It was a small account at the time. I didn't really have a lot of my own knowledge about what the options were. I didn't necessarily look at this particular person and say, he is going to take all of my best interests in mind. He was offering me a service, offering me an option, and giving me information. And without...
Thank you. I appreciate it. I yield back, Madam Chair.
Gentleman's time has expired. The chair now recognizes the gentleman from New York, Mr. Garbarino, for 5 minutes.
Thank you, Madam Chair. Thank you for hosting this hearing. Thank you to the witnesses for being here. Ms. Neely, I strongly support a diverse marketplace offering various options for consumers to achieve their financial goals. Does the DOL's fiduciary rule pick and choose the types of investments it deems most appropriate for retirement savings?
Well, certainly in our read of the proposal, there seemed to be a lack of understanding at a fundamental level about how annuities work. They reference a study that talked about investments and return on investment, which is annuity is insurance. The benefit of annuity is it provides protected income for life. And so, yes, to give a shorter answer to your question, we think DOL is missing the fundamental benefit of annuities and conclude from that they must have an annuity bias.
Do you think it's appropriate for the rulemaking to exhibit such a bias, like you said, against a particular investment?
Well, I think any bias against an important product that can be part of a sound financial security plan is harmful to the very goal that we all share here, which is to close the retirement savings gap.
Appreciate that. Thank you. Mr. Cadin, there is currently a $7 trillion retirement gap in the country. In response, Congress made strides to help close this gap through Secure and Secure 2.0. Can you discuss how this new proposal will affect retirement savers and the advancements that Congress has made in recent years?
I don't think there's any question that if the Department of Labor is allowed to go forward, it will actively thwart the bipartisan will of Congress. You've worked really hard in a bipartisan way to bring people together, get people more access to savings, to provide safe harbor rules for annuities, to provide to provide illustrations. The Secure 1 and Secure 2 are land-breaking pieces of legislation, and if Department of Labor is allowed to go forward, it will actively undercut those efforts.
Can you, so many of the financial professionals, I met with them, are small businesses. How do you think this will affect those small business operations, this rule?
I think they will stop offering advice. As the NAFA's done some tremendous work here. We work closely with them, as the NAFA survey clearly shows that they're going to have to impose minimums. They're going to hire staff to help manage these accounts. That'll reduce the time they spend educating clients. And the net result of that is that millions of Americans are going to lose access to financial advice that they need.
And as Ms. Neely just said, it appears that this rule is really targeting annuities. And they're often criticized as expensive and overly complex. But I don't think this could be further from the truth. In an effort to clear the air, given the administration's recent rhetoric on the usefulness of annuities, can you please explain how annuities are the same or different from investments in securities?
Ernst & Young says that if a consumer has permanent life insurance investments and annuities, they get better outcomes, because the insurance, as Susan said, annuities provide guarantees. They are insurance products that are not subject to market risk in the same way that equities and bonds are. So they work in a complementary fashion and should be encouraged, not discouraged. And I think it's not just that the Department of Labor is targeting a product. I also think they have a bias against a compensation and a business model, and they are on a 13-year crusade to ban commissions, in my judgment.
I have to say, as someone who was in private practice as an attorney before I got to Congress, who dealt with elder law care and estates, I personally saw the benefits to my clients that annuities gave. So I think that this rule could do a lot of damage. I have some time left. Ms. Elliott, does your firm offer life insurance or other types of guaranteed lifetime income products?
Yes, our firm does offer life insurance and guaranteed income products. And one thing I want to make sure
Well, I just want to ask, because I only have a couple of times, and you get commission on that.
that is correct,
Okay.
yes.
And I see on your website that your firm offers financial planning services fees that start at $4,500 for individuals, $6,500 for couples, and $10,000 for small businesses. And if you have an asset under management fee schedule for accounts up to $500,000 of 1.2%. So over a decade, that would be 12% deducted from your customer's account. So my question is, how does that compare to commissions paid by an insurer for the sale of an annuity?
That's a great question. So with that AUM fee, we offer holistic financial planning. We do a retirement plan for our clients. We do budgeting. We do education planning and analysis. We help our clients with major financial decisions in their life. So one thing that's really important is ours is not a one-time transaction. We are speaking to our clients on a consistent basis.
I'm out of time. Madam Chair, I yield back.
Gentleman yields back. The chair now recognizes the gentleman from New York, Mr. Lawler, for 5 minutes.
Thank you, Madam Chairwoman, and thank you to our witnesses for being here and helping address our concerns on this important topic. I know my colleagues have raised a lot of different concerns here, but I'd like to turn back for a moment to the core of the decision to pursue this proposal. The proposal we are discussing today is strikingly similar to the failed 2015 DOL Fiduciary proposal. But there are some key differences between 2015 and today. Most notably, the SEC finalized Regulation Best Interest, which requires broker-dealers to only recommend financial products to their customers that are in their customers' best interest. Furthermore, 43 state insurance divisions have adopted a similar best interest standard established by the NAIC. And lastly, we have a Fifth Circuit ruling that states the DOL overstepped its statutory authority when it proposed the 2015 rule. Mr. Campbell, given these factors, do you think that the recent DOL proposal is necessary?
I would argue it's absolutely unnecessary. I would also argue that it is not consistent with the Fifth Circuit and needs to be withdrawn.
Considering the Fifth Circuit ruled the 2015 proposal was outside the statutory authority of the DOL, do you believe the recent DOL proposal is outside the statutory authority of the DOL?
I do, because it attempts to apply a fiduciary standard to individual retirement accounts under Title II of ERISA, which Congress never established a specific standard of care for. They were to fit into the existing financial regulatory system, where in my IRA, when I go to an insurance producer to buy an annuity, when I go to a broker-dealer to get securities assistance, when I go to a registered investment advisor to get fiduciary advice, those are all choices I have, and the standard applicable to that professional applies. DOL is trying to change that without congressional authority to do so, so that the ERISA standard from employee benefit plans would be essentially the governing principle, and they don't have the authority to do that.
Mr. Berkowitz, do you agree?
Yeah, I would 100% agree, Congressman, and I would actually just quote from the Fifth Circuit decision where they specifically said, and we've heard a lot about this supposed gap. So even if we were to put in, for argument's sake, assume that there were a gap, which we don't think there is, the court said a perceived need does not empower DOL to craft de facto statutory amendments or to act beyond its expressly defined authority. They are clearly going well beyond that with this regulation.
Mr. Cadin?
Without question, they are going beyond the clear, unambiguous ruling of the Fifth Circuit. I would just say, I hope that we don't get to a lawsuit or litigation, because I really think it's the responsibility of Congress to stop the department from doing what is clearly going to harm millions of Americans.
Ms. Neely?
Well, I agree with what's been said, well said by the other witnesses, and could not agree more. It would be wonderful to avoid litigation, because that's just more time and resources on something that is not necessary. We welcome Congress taking action.
So in 2018, the U.S. Court of Appeals for the Fifth Circuit overturned the Department of Labor's 2016 fiduciary rule, deeming it an arbitrary and capricious use of regulatory power. I know you discussed this earlier, how the Department of Labor's most recent iteration of the fiduciary rule barely differs at all from the version that was invalidated by the courts in 2018. Mr. Campbell, since the Fifth Circuit's decision was issued, the Supreme Court has also issued its West Virginia versus EPA decision, which confirms and clarifies the major questions doctrine. Isn't the new proposal ripe for being overturned, given its similarity to the 2016 proposal and the newfound interest in the major questions doctrine since the Fifth Circuit decision?
I think that's an excellent point. When this was litigated in 2018 in the Fifth Circuit, the major questions doctrine had not been determined by the Supreme Court. And essentially, this is a very appealing case for that issue, because for 40 years, the Labor Department's own regulations and guidance embraced the same view of fiduciary. They only changed it and only discovered a whole new power to regulate an additional $13 trillion in IRAs in 2015. So that is an example of the statute has remained the same, yet suddenly a newfound power emerges. That is the essence of the major questions doctrine. So I think that will be an issue should we get to litigation, which again, I would echo the calls of the others here for Congress to not let it get that far. But if we get to litigation, I think that will be one of the issues that arises this time that did not last time.
Thank you. I yield back.
Gentleman yields back. The chair now recognizes the gentleman from Massachusetts, Mr. Lynch, for 5 minutes.
Thank you, Madam Chair. To begin, I would just ask unanimous consent if we could enter into the record a report from Consumer Federations of America. It's entitled New Offerings of Crypto in Retirement Plans, underscores the need for Department of Labor fiduciary responsibility.
Without objection.
Thank you, Madam Chair. Ms. Elliott, I'm a former trustee for a union pension plan, so I've got a little bit of a bias on this, but according to a recent survey conducted by Consumer Federation of America Institute, 94% of state and government pension plans sponsors indicated that they invest in cryptocurrencies, and so do about 62% of corporate defined plans, and 48%, defined benefit plans, and 48% of corporate defined contribution plans. Now apparently you can even roll over your traditional IRA or your 401k into a Bitcoin IRA. In a recent analysis, the CFA, the Consumer Federation of America, warns that, quote, the unique features and risks of the crypto market would make it challenging for even those with specialized expertise in crypto markets to make diligent and prudent decisions about offering these assets to retirement savers, specifically to retirement savers. As a result, employers who sponsor retirement plans are going to rely to much of their extent on professional financial advisors in deciding whether to offer crypto assets to their workers. Considering the unique challenges, and you know, we all saw FTX explode. I believe the Canadian Teachers Union lost about $95 million when that exploded, and we saw, actually on the subcommittee on digital currencies, we saw that FTX, just before they crashed and burned, they were soliciting individual IRA holders and trying to get small investors to invest in their crypto. Considering the types of decisions that maybe even experts are going to have difficulty with, can you talk a little bit about the challenges that the average vulnerable investor might have?
Thank you for the question. And I think it's an important question where we're not against any specific product. I'm not against annuities. I'm not against life insurance. I have life insurance. I'm not against crypto. I think the important conversation here is when you recommend these products, are you doing so in the client's best interest, right? Are you asking the client about their risk tolerance, their time horizon? You know, what is their financial knowledge and awareness of the product that you're recommending? And I think what you just shared with us, Congressman Lynch, about cryptocurrency and the opaqueness and newness of this new security does create some issues and can be troubling. But I think that, you know, with my colleagues here, you know, sharing a little bit about, there's always going to be education. There's always going to be ways that you're going to spend money to become better financial advisors. I want to address one comment that was made earlier, is that there's going to be more training needed to adhere to the Department of Labor fiduciary rule if it were to continue. But I think any training that helps your financial professionals act in the best interest of clients is a worthwhile investment. What else are you spending your money on? So I think that, you know, your comment is really well taken in understanding that we really want to make sure that financial professionals are astute, are helping their clients, and are doing so for retirement security.
I have one more question. So a lot of asset managers are now using AI. They're using artificial intelligence to help them make investment decisions. The problem is some of the deep learning AI have problems with explainability. In other words, they'll recommend you do something, but there's no reasoning behind it. Mm-hmm. So I don't know, it creates a quandary where if my asset manager loses all my money, I would like an explanation, but I'm not sure they'd be equipped to deliver that.
That's correct. You know, one thing I always state when working with my clients is that if I can't tell you the why and the benefit for you, I should not be recommending it.
Yeah. I yield back, Madam Chair. Thank you.
The gentleman yields back. I'd like to take this time to thank our witnesses for their testimony here today. Without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses to the chair, which will be forwarded to the witnesses for their response. I ask our witnesses to please respond as promptly as you are able. This hearing is now adjourned.